Welcome to The Next Fight. I'm Don West, National Trial Counsel for CCW Safe. In today's video, we will be talking about discovery. Once the case has been formally charged by indictment or information, the discovery phase begins. Simply said, discovery is the exchange of information between the parties. What this information consists of and how it's exchanged will be controlled by rule and statute. A statute is actually just another name for a law that's been passed by the legislature. All criminal offenses are identified in the statutes, and the statutes set forth the elements of the offense that the prosecutor has to prove in order for you to be convicted. Discovery in most jurisdictions will include the police reports, witness statements, including any statements you may have made, lab reports on evidence that has been analyzed, the autopsy report, toxicology reports, ballistic reports, crime scene photos, evidence collection logs, and likely much more. The defense usually has some reciprocal discovery obligations and may have to provide access to physical evidence it intends to offer. They may also have to provide certain witness statements and perhaps a witness list. Some jurisdictions have wide open discovery, where the prosecution files are almost completely accessible to the defense. For example, in a handful of states, the lawyers can take the deposition of prosecution and the prosecutor can take the deposition of defense witnesses. A deposition is sworn testimony before a court reporter that can be used for impeachment if the witness changes his or her testimony and can be used to help identify other witnesses or evidence in the case. Other jurisdictions are more restrictive with what the prosecution has to give up. One of the worst for this is the federal system. Most states have far more liberal discovery than the feds. Trial in federal court is sometimes called trial by ambush, and for good reason. In a series of cases, the United States Supreme Court has decided that separate from the local rules of discovery, a prosecutor must provide any information he acquires that would be exculpatory, meaning that the evidence would tend to support innocence. For example, if a witness identifies someone else as the culprit, that would have to be disclosed. If physical evidence is tested and shows someone else's DNA, that would have to be disclosed. If a witness changes his testimony or recants, that would have to be disclosed. If a witness has been offered a benefit for his or her testimony by way of a reduced sentence, reduced charges, or even dismissal of charges, that has to be disclosed. Many of the falsely accused have been wrongfully convicted because the prosecutor failed to disclose evidence damaging to his case. Sometimes it takes years for that to come to the surface, if at all. The prosecutors would be willing to pervert the system just to get a conviction is one of the criminal justice system's worst disgraces. Following the filing of formal charges, the lawyers will begin to exchange information and the accused will, for the first time, get a first-hand look at the evidence against him. Most, if not all, homicides will have physical evidence that can be analyzed. This might be of firearms, a gunshot residue or distance analysis, DNA analysis, trajectory analysis, blood splatter, voice recognition or identification analysis, fingerprints, and of course the list goes on. Usually the physical evidence is submitted to a state-run lab by law enforcement. Sometimes the FBI is asked to analyze specific evidence or an outside lab is used for drug testing. Eventually, that evidence is analyzed and the analyst will prepare a report of the findings. Often there's no dispute about the findings, but there certainly can be legitimate claims made in some cases that the testing was flawed, the lab contaminated, the analyst incompetent, for example, the fingerprints too smudged to analyze, or a whole host of other problems. Upon a request to the judge, the defense should be allowed to have its own independent expert perform a separate analysis, and if that analysis is different, the defense expert can be called to testify at trial. This is common in areas where there's considerable subjectivity in the expert's opinion, like pathology or tool mark identification. It's not at all uncommon for a defense expert to take the stand and testify that the prosecution expert's findings are wrong and offer a different opinion about the testing and conclusions. The discovery phase is usually the longest phase of the case. It can often take weeks, months, or even a year or more for the lawyers to review the evidence, investigate the case, test the evidence, and prepare for trial. Along the way, the lawyers may change their initial impressions of the case and decide that their position is weaker or stronger than they first thought. Perhaps the defense is able to produce a witness that is believable and who dismantles the prosecution case, or perhaps the lab reports show that the accused is telling the truth after all. Then it's possible that the case can be dismissed prior to trial. If a prosecutor becomes convinced along the way that they are prosecuting the wrong person or that the evidence is flawed and they can't prove the case, then they are ethically bound to abandon the prosecution. But because a prosecutor can make his own interpretation of the evidence or the credibility of the witnesses and may be influenced by political pressures, don't hold your breath that the case is going to be dismissed. Thanks for watching. I'm Don West for The Next Fight.